The fate of the 2012 elections lies squarely with President Mwai Kibaki and Prime Minister Raila Odinga or their respective parties PNU and ODM. This is according to a landmark ruling delivered today by the High Court, giving two possible options for the elections to be held. In an attempt to clear the air on the exact dates the first general elections will be held, High Court judges Isaac Leneola, Mumbi Ngugi and David Majanja pointed out that in reference to Section 9 and 10 of the 6th Schedule, the first general elections can be held within 60 days from the date at which the coalition government is dissolved, which can only be achieved through a written agreement between the President and Prime Minister in accordance with Section 6B of the National Accord and Reconciliation Act of 2008. It is the first time in a long time that Kenyans have been left in the dark on the election date, and ironically, it is caused by the Constitution, yet one of the influencing motives for it was to clear the ambiguity on election dates.
That the first elections under the Constitution can only be lawfully held as follows. 1. In the year 2012, within 60 days from the date on which the national coalition is dissolved by written agreement between the President and Prime Minister in accordance with Section 6B of the National Accord and Reconciliation Act 2008.
The second option the judges gave was that upon the expiry of the term of the 10th Parliament, that is on the 5th anniversary of the day it first sat, which is designated by legal notice as 15th January 2008, its term therefore expires on 14th January 2013. Elections shall then be held within 60 days of 15th January 2013.
Within 60 days from the date of the term of the National Assembly, which is the 15th of January 2013.
The High Court, however, ruled that the only body under the Constitution that has the mandate to fix the date of the first elections under both options is the Independent Electoral Boundaries Commission. For the country to conduct elections in December 2012, the Attorney General is expected to advise the true principles to dissolve the coalition government by October in order for the IEBC to be able to set a date for December elections, or else the second option will take precedence. Setting of the election date will clear the air on by which date political parties will be required to have fully complied with provisions of the Political Parties Act and Elections Act. It will also shed light on controversy-ridden debates such as when exactly civil servants who intend to contest for public office are expected to resign from their current jobs. The date will also clear the air on the deadline for parties to conduct nominations for their candidates for the various positions ahead of the next general elections. Right now, it would appear that all these issues are marred in ambiguity.